All right, live in 3, 2, 1.
Thank you. Good evening, everyone. This is a call to order for the special meeting of the Bridgeport Board of Education. Today is Wednesday, September 27th, 2023. It is now 6:03, and we're meeting virtually. At the moment, for the first item on our agenda, there is no public comment. No one has signed up. And then our next item is presentation and discussion of duties and legal responsibilities of board members by Bertram and Moses. And I'm just going to outline the areas in which we'll cover this evening. And then Mr. Dugas, you have the floor. The first one is board roles in the community, board function, superintendent of school function, role of board attorney, collective bargaining and employee discipline, Freedom of Information Act, Robert Rules of Order, and do's and don'ts. This tonight's presentation will be covered by Mr. Floyd Dugas from Bertram and Moses. Mr. Dugas, you have the floor.
Thank you, Ms. Brown, and good evening, everybody. I hope everybody is doing well. The presentation that I'm going to do, I hope will accomplish at least two things. The first is to give everybody sort of an overview of the legal authority that allows you to do what you do and requires you to do certain things, and then focus on the relative roles and responsibility of the board and of the superintendent. I'm going to touch just generally upon the Freedom of Information Act and Robert's rules, because that could be an entire presentation in and of itself, but I will just touch on a high level because those are some of the rules and laws that come into play. Some of you have heard this before, but I'm a firm believer in it's always good to get a refresher on this stuff. For those of you who haven't, hopefully you get some great takeaways. So let me start, if I may, with just a little bit of a primer on the law that drives what you folks do. And informs much of what you do or should be doing. And believe it or not, this all starts with a line in the state of Connecticut Constitution. And that line guarantees a free public education to all the children of this state. Now, you might think that, well, that's an obligation of the state of Connecticut, but what they have chosen to do is to delegate that to local and regional boards of education. So effectively, they've said, we've got this wonderful obligation to educate the children of this state, local boards and regional boards of education. It's now on you. So that's effectively where we start with this whole process. Now, the question that often comes up is a Board of Education an agent of the state because of that, or is it an agent of the city? And the answer is really both. You're an agent of the state, and you are primarily responsible for some of the things I'll talk about in a moment. But at the same time, of course, you are a department of the city of Bridgeport, and you are subject to certain of the requirements that the board imposes, typically things that are in the charter. So you're really an agent of both, and you have to be mindful of that. But importantly, you are carrying out the role and the obligation of the state to educate the children of the state. Now, if I ever had an opportunity to show you all the laws and regulations that come into play for a school district, it would be, probably 20 feet or more long, because there are many state laws. There are also federal laws, particularly when it comes to things like special education and federal grants and so forth. But you've got to comply with state law, various federal laws, and even some local laws. Now, much of that you'll never see, but just understand there's a lot of laws and a lot of regulations that overlay what you do. What I point out here in the document, which should have been distributed to you all, if not, hopefully will after, are a couple of the most critical statutes that govern how things work. So the first one, remember I said that the state delegated to you responsibility for educating the children. That really comes from the first statute you see there, Connecticut General Statutes 10-220. And in that statute, they delegate responsibility for, quote, maintaining good public and secondary schools, and to implement the educational interests of the state. And then it goes on to list a bunch of duties, providing books and providing a safe school setting and all of that. But that's really the main grant of authority for you and in what you do. The second major statute that comes into play is Connecticut General Statutes 10-221. Now, what it says on the face is that it gives the board broad authority to develop policies for the management and discipline of schools regarding homework and attendance and promotion, student promotion. And there are a number of other policies that are mandated in the law. But this is really, although it doesn't come right out and jump out at you, what this is really saying is your primary responsibility, aside from the overarching one to provide for good public and and secondary schools, is to develop and establish policy. That's the board's primary role, developing policy. And I'll talk about how that gets implemented later on. Another very significant statute is the budget process, the statute that governs the budget process. And that's 10-222, and it requires you to submit, as you know, all too well, an itemized estimate of the cost for running the schools. You submit that to the city, and ultimately they make a single dollar appropriation. And once they've made that appropriation, it is the district's responsibility to decide how to spend that money. They can't dictate how you spend it once that appropriation is made. The importance of that, incidentally, is when I talk about the other statutes, particularly 10-220, and what in your responsibility to maintain good public and secondary schools, that's really mostly done through the adoption of a budget. So that's the significance of that. And then I always think it's important to point out that there's another statute, which is 7-349. And what that says is that expenditures for the district may not exceed the appropriation. And under the statute, if it does, members may be held liable. So you as board members, it's very important that you understand that expenditures are within the budget, and at the end of the year, the expenditures don't exceed the revenues. A couple other statutes I'll mention just briefly. One is 10-240. You'll hear the term, we use the term school district, and even us lawyers tend to use it sometimes a little loosely. I probably did already, but when we use the term school district, in this case, it is the city of Bridgeport. Then let me just mention something about the buildings. The buildings are owned by the city, but as long as they are being used for educational purposes, you have complete control over how the buildings are utilized and what happens with the buildings. Once you're no longer using a facility for educational purposes, it's typically turned back to the city, and then the city can do with it what it wants. But while you're using it for school purposes, it's totally within your control. Now, The next item that we see here that I've got is probably one I can't echo enough, which is that the board acts only via meetings such as this. Okay. If the board is not sitting in a meeting, it doesn't have any authority to take any actions. Also, however, board members have no authority unless they're sitting as a board. Okay, so a board member doesn't have authority to walk into the school and tell a principal, you know, I want to do this or I want to see that or the other thing. They've got no authority to say, I want to see the evaluation of teacher X, Y, or Z. Only when you're sitting in this meeting do you have the authority. You folks, like a lot of districts, have adopted bylaws. I know some of you are very familiar with the bylaws. If you have not made yourself familiar with the bylaws, I encourage you to do it. It is really, it's sort of the law of the board. So I talked about the fact that you have the state constitution, and then we have various statutes that tell you what to do. But the bylaws are, as it suggests, is a law, if you will, that governs how you do certain things, and you need to follow those. I've noted two here in particular. One is the code of conduct. The other is the policy on conflict of interest. I encourage you to look at those in particular, because it certainly guides how you conduct yourselves. There's also a code of ethics in the city, and you could be subject to an ethics complaint. It covers very similar things, but generally what we talk about here is if you have a financial interest in a particular matter, that can be a conflict of interest, and you need to, at a minimum, disclose that, if not recuse yourself. And again, the code of conduct sets forth various conduct that you and your predecessors have decided govern how you should conduct yourselves. Okay. I mentioned here indeed the Freedom of Information Act, but again, I'll come back to that. I just mentioned it here because in addition to your bylaws, in addition to any relevant city charter provisions, another very important law that reflects how you conduct yourself is the Freedom of Information Act. And again, I'll come back to that. All right, I'm moving on to individual board member qualifications and authority. And the first thing I note is that to be eligible to be on a board, you must be a, quote, elector of the town, or in this case, the city. And that means that you have to be at least 18 years of age or over, and you must be a resident of the city. Secondly, your employment is prohibited. If you are a board member, you cannot be employed by the board in any capacity, not as a coach, not as a referee, in no capacity whatsoever. That's prohibited by the statute that you see there. That doesn't mean that you can't work for the city, but you can't work for the Board of Education. The next item that I have here is legal exposure. One of the things that I say to new board members, one of the unfortunate realities is that, so it doesn't come as a surprise, it is very possible that someday you will be named personally in a lawsuit, and there are tactical legal reasons why a lawyer may choose to identify you in a suit. You know, there are technical reasons, but sometimes it's frankly just to put pressure on individual board members to settle whatever it happens to be. But what I say is, you know, don't be overly concerned about that, because there are a number of protections. The first is that the concept of governmental immunity. And for the most part, there's broad governmental immunity that comes into play, and lawyers will assert on your behalf if there ever is a suit. The second is in a statute 10-235, and what that statute says is that the board, the district, through the city, must indemnify you if, in fact, there is a lawsuit brought, and in the unlikely event that you are found to be responsible for damages. Now, there is an exception to that, and that is if you are acting in good faith, you're covered and you're indemnified. But if you act willfully, recklessly, or intentionally, then you are not subject to indemnification and there's exposure. So basically, as long as you're acting in good faith and you have the right reasons for doing what you're doing, that's fine. But if you do something reckless or willful, and then there is the potential for some exposure. So just to give you an example, let's say that somebody, is really out to get an employee. They basically, scheme to do it, then that if you're sued, that could be found to be willful, and the indemnification would arguably not apply. So as long as you're acting in good faith, you should be fine. In addition, there's insurance. The city is both insured and partially self-insured, and there's insurance. But even apart from the insurance, there's still the obligation to indemnify, so you should be okay. Now, but there's a concept in the law that's called an ultra vires act, and that's a Latin term that basically means if you do something that you don't have the authority to do, it could lead to liability. So the closest I came to that situation was in another district where a board member, for lack of a better term, colluded with a vendor for a roof replacement job, and they basically said, yeah, I'm going to get it for you, that it's your contract, words to that effect. It didn't ultimately get approved. The full board didn't support it. There was a lawsuit, and the claim was that this board member had bound the district, when in fact, as we know, a board member acting by themselves has no authority, and it created liability, and it was outside the board member's authority, and there was exposure for the board member in that case. Ultimately, it worked out, but that's the kind of example where that may come into play. And then Connecticut General Statute 7-4765, what that provision says is, notwithstanding indemnification, if you slander somebody or defame them, Floyd is a rotten so-and-so and a bad person. If you make that, statement like that and you slander, then that would be an exception to the indemnification. And if whatever you said about Floyd turned out to be untruthful, and I sued and got a judgment against you, you could not turn to the district and ask for indemnification. So be mindful of that. We certainly should never defame or slander somebody, but relative to the question of personal liability, just be aware of that. And then the fourth point on this page is that no individual board member, I mentioned this before, but no individual board member or subcommittee possesses any authority unless in accordance with a duly authorized board action of some sort. Now, you guys all wear two hats, of course, or probably many hats, but one of the hats is as a board member, and another hat is as a private citizen. And although most boards try to have one voice, when something's decided, folks support it. You do have a right to express your personal opinion. What we generally say, though, is if you're going to do that, try to make clear that it is your opinion and not necessarily the opinion of the board that you're expressing. The last item under 5 that I have there is participation in PTOs or similar organizations. It is not prohibited by any law, but just as an example, CABE in policy statements has discouraged that, because what tends to happen is instead of focusing on what's best for all the children in Bridgeport, people tend to focus on, a particular issue or particular school, and so that's discouraged. But I'm not here to tell you that you can't do that, just that it is discouraged. All right, I'm going to start to now get into begin to talk about the function of the board, the role of the board, and eventually we'll get to roles and responsibilities more specifically between the superintendent and the board. So first item that I have there, of course, which I've touched on, is it is your obligation to promulgate policy. In fact, that's your single most important obligation. It is also your primary responsibility. So generally, you set goals for the district, aspirations for the community, things that you want to accomplish. You formulate a policy around that, and then you evaluate the performance to see how you're doing, and then you amend the policies as you think it's appropriate. Again, most of you are very familiar with that process. And then importantly, the administration is the one that's responsible for implementation. So the board sets the policy, the administration carries that out. I mentioned item 2 here, which is that many of your other responsibilities about maintaining good public elementary and secondary schools and implementing the educational interests of the state are affected through adoption of a budget. So that's certainly another important role that you play. And then the third, hire and evaluate a superintendent. You all did that recently, and the way that the laws are set up, you have one and only one employee, and that is the superintendent of schools. He or she, in this case, she is responsible for all the other employees of the district, but keep that in mind. She is your one employee, and everybody else does not report to the board and isn't considered directly a responsibility of the board. You also, under 2 statutes, which I'll talk about shortly, one for certified and one for non-certified employee, have a duty to bargain collectively with your unions. That is typically delegated. In this case, I'm, for example, the chief negotiator in connection with the teacher negotiations that are going on currently. I am your representative. You have a representative on the board sitting in with us, Ms. Baptiste Perez, who's there to communicate back to you the status of what's going on and making sure that we're doing what it is you would want in those negotiations. But at the end of that process, whatever we agree to, we have to bring back to you, because ultimately it is your authority and responsibility for those for the collective bargaining agreements for the in this case the teacher and the administrators. Bridgeport, of course, has an unusual arrangement where the non-certified folks are part of a city board collective bargaining process, but certainly with respect to the certified, that is your primary responsibility. Another very important and significant responsibility is student expulsions. Under the law, you have the option to either hear them yourself or use a hearing officer. My recollection is you guys use a hearing officer, but you can do either one. Given how much volunteer time and commitment goes into being on a board of education, we generally suggest a hearing officer. Those hearings can be very technical from a legal standpoint, and it's helpful to have a hearing officer, very often an attorney, who's familiar with those requirements. And also it avoids you having to be out, dealing with student discipline matters in terms of hearings and so forth. School accommodations, a residency issue, a bus stop issue, those ultimately fall within your responsibility. And then you also, item 7 here is play a role in the grievance process. Again, at least as it relates to the contracts over which you have authority. In this case, the Board of Education, the teachers and the administrator bargaining units. Again, a number of you have been party to grievance hearings when we've had to have those before you, and I'm going to talk a little bit more about that at the end, but that's another very important role that you all play. Another situation that may come up are teacher termination hearings, and what I'll just say a couple of things about that. First of all, there's a statute that covers teacher terminations, and it lays out very specific roles and responsibilities. The superintendent initiates the process, and then the teacher has a right to either come for a hearing before the Board of Ed, or to go before an independent hearing officer. 90 to 95% of the time, teachers are going to go before an independent hearing officer. But when it's all said and done, if it's a hearing officer, they make a report that has findings and recommendations. Those findings and recommendations come back to you, and then what you serve in what we lawyers call a quasi-judicial capacity. You're sort of the judge and the jury, or a combination. And for that reason, the law requires that we provide you with little or no information before that comes back to you, so that when it does come before you, you've got a completely open mind on the issue, which is what the law requires when you finally make a decision. Let me just say, by the way, most teacher separations should, and in fact, never do get to you, because if the administration is doing its job, it has documented those situations, it has counseled the employee, and very often there's a resignation of some sort, so that it never ends up in a hearing. But it does happen from time to time, and that is an important role that you play. These presentations, whether it's done by myself, done by CABE, even if it's done at the national level by the National School Board Association or the National Attorneys Council, one of the points that's emphasized heavily is the chain of command. And I would say, whether you're in a law firm or whether you're on a football team or in the police department, chain of command is extremely important for a number of reasons. Number one, you want to resolve things at the lowest level possible. If every gripe went to the superintendent, she'd be even busier than she is right now and would have a hard time getting anything done. And so therefore, the chain of command should be respected and followed. And that, of course, is parent complaint should first go to the teacher. If they're not satisfied with that, it should go to the principal. If they're not satisfied there, it should go to the superintendent or perhaps an appropriate director. It should not go to a board member. Board members are not in the chain of command. If you find that the superintendent is not dealing with this or other situations properly, then you deal with the superintendent, but you should not be involved in any issues, whether it's a personnel matter, whether it's a student matter. The chain of command should be followed and respected. You'll hear the term FERPA, probably have already, but it's a federal law. And basically it says that any personally identifiable information about a student must be maintained confidentially. And therefore you'll find that school districts, including yours, are and should be very careful not to discuss students, except for those that are need to, the teacher, special education teacher, and so forth. and that's based on a federal law known as FERPA, and the consequences are potentially pretty significant under the law, and that's a federal law. You can have your federal funding withdrawn or denied if you're applying for federal funding if you violate FERPA, and so therefore we're very cautious about student information and data. And the last point, the board is not supposed to be involved in day-to-day issues involving running the district. So, and that relates particularly to student and personnel matters, as I mentioned, but that is left to the superintendent and the employees of the district. At least that is under the statute, and according to every board attorney, and again the National School Board Association and others, that is how a district is supposed to operate. Going to turn now to the function of the superintendent, and then we'll do kind of a compare and contrast. Under the statute, which you've again recently gone through, your job is, I'm sorry, the superintendent's job is responsible for the day-to-day operation of the schools. It's kind of a funny term, but in the statute, it refers to the superintendent as the CEO of the Board of Education. And it provides that they've got executive authority over the schools, as I've mentioned a couple of times, and is responsible for supervising and evaluating all staff. The superintendent is, again, it's a funny term, but is elected by the board, and you did that recently. Unlike other certified employees, the superintendent has no tenure. And that's why we typically give superintendents in the state a 3-year contract. I can't remember the last time I saw one that wasn't 3 years. And the reason that is done is not only to give them sufficient time to accomplish what they need to, but also sufficient time if for one reason or another things aren't working out, so that they can make plans. But that is, and let me just add that you cannot have a contract that is more than 3 years. It would be prohibited by statute. So, for example, if you're going to do an extension, or you decide a year from now to do an extension, we would not simply extend the contract and make it a 4-year. What we would do is generate a new 3-year contract beginning next year and going 3 years forward. And that's why we do that, because it's contracts in Connecticut. Superintendent's contracts cannot be more than 3 years. The superintendent is required by statute to submit an annual report to you. The superintendent is entitled to be evaluated annually, and I know you've done that process in the past and are familiar with it. The superintendent initiates teacher terminations. I touched upon that previously. There's a statute dealing with tenured teachers that has some pretty rigid requirements. I've said in the past, and I believe this, that the procedural hurdles you have to go through to terminate a teacher are the most difficult of any employees, public or private sector. There's a process there, and one that we have to make sure that we follow. A non-tenured teacher is a little different. They're almost like a probationary employee. The difference is they're entitled to some limited process. And again, if things are being done right, you will never have to get involved in that process, because somebody who's not cutting it is counseled out, and that's how they terminate. With respect to non-certified staff, of course, the vast majority of yours are in unions that are covered by collective bargaining agreements. Those collective bargaining agreements require just cause to terminate somebody. For anybody who's not in a union, they are generally speaking entitled to some form of due process prior to letting them go. So, if you saw that in the paper, somebody was arrested for selling drugs, you couldn't just say, I'm talking about a non-certified individual who's not in a union, you couldn't just say, well, let's just fire them. You've got to give them some minimal due process as a result of that. You folks have a specific policy with respect to hiring of certified staff, just be aware of that. Now, in this next document, and I have to give credit where credit is due. I've borrowed this from CABE, so this isn't the world according to Attorney Floyd Dugas, although I agree with it. But it is a document CABE puts out that tries to be very concrete in terms of some of the roles and responsibilities between the board and the superintendent. So I'm not going to go through all of them, but just to give you an example, the first one we see there is the board's role is to hire, support, and evaluate and work effectively with the superintendent. And the superintendent's role is to work effectively with the board, serving as the board's chief executive officer and educational leader for the community, for the board, and for the district and the community. The second item you see here, as I noted before, the role of the board is to establish and regularly review all policies, ensuring they are lawful, designed to improve the quality of the school district. On the flip side, it is the role of the superintendent to implement those policies once they've been adopted by you, and to make recommendations to you about the policies if she thinks that changes are needed. The third one here talks to the evaluation process. It's pretty self-explanatory, so I won't cover that. The next bullet point, you'll see the board's responsibility is to inform the superintendent through the established chain of command of potential barriers to realization of the board's vision for the school system. And the responsibility of the superintendent is to proactively identify and address potential barriers to the realization of the board's vision and to bring that to the board's attention. The next one, to refer communications such as questions, complaints, and personnel inquiries to the superintendent as appropriate, and to encourage adherence to the established chain of command. Teachers complaining, you should not go to the principal and call him on the carpet or try to get involved and mediate. You should refer that matter to the superintendent and let the superintendent respond to it. And of course, the other side of that is superintendent's responsibility is to respond to it as appropriate and address the situation. And then if necessary, keep the board apprised of what's going on, but the board should not be directly involved. Skip ahead. This gets into the budget process a little bit, which we've touched on, but board's role is to adopt, advocate for, and oversee the school budget, which is designed to meet the needs of the district. And then the superintendent's responsibility to prepare, advocate for the implementation of the budget, and to report to the board any concerns about the budget, so we don't get into that situation I mentioned, where you might end up with a deficit at the end of the year. Next item, to delegate to the superintendent responsibility for all administrative functions, except for any that might be reserved through board policy. An example might be hiring of principals and above. Statute allows you to reserve some right, and you guys have done that through one of your policies. Forgive the cars outside. So I think you get the gist of what's going on here. Very, much of this is to point out that the board sets policies, the board follows the chain of command, the board lets the superintendent know if they hear something, but it is the superintendent who runs the schools day to day, deals with personnel issues, deals with student issues, and that should be her responsibility, and the board should not be directly involved in that. I just mentioned a little bit about the role of the board attorney. You know, we represent the board. We don't represent the administration, the superintendent. We certainly work closely with the superintendent and her administration on any number of day-to-day issues. Importantly, we provide advice, but we're not the decision maker. Sometimes people think we have more of a role or influence in that way than we do, but all we do is provide advice, and we hope that folks generally follow the advice. So usually they do, in rare instances they don't, but we do provide advice and not decisions. There may be some rare occasions where separate counsel is needed, and I'm thinking, for example, when it comes time for a teacher termination case, sometimes the board will want, for example, you know, separate counsel sitting with it and advising it. But if and when that becomes necessary, we can come up with that. We can discuss that. I just note that you know, sometimes we get caught in the crosshair with unpopular decisions. It might be the firing of a popular coach or something of that nature, but that just comes with the territory. And while you folks probably see me more than any other member of my firm, there's, of course, we're a firm of 35 lawyers. We have folks who specialize in special education in particular, including my partner, Marcia Moses, but other members of the law firm. We also sometimes get involved in litigation. You've seen my partner, Richard Berterla, before, who heads our litigation department. And there are certainly plenty of other folks if needed. The law firm is your lawyer, although you see me probably more than anybody. I want to talk a little bit about collective bargaining and employee discipline. I mentioned to you there's a couple statutes that govern the labor relationship there, the labor context. The first is called the Teacher Negotiation Act. As you know, it's pretty self-evident, but it governs not only teachers, but administrators, all certified staff. The one that governs non-certified unionized staff would be the Municipal Employees Relations Act. They're very similar laws. If any of you ever had any dealings with the National Labor Relations Act, they're modeled after that, but they guarantee certain rights to employees, in addition to the right to organize, to the right to, they impose an obligation to bargain in good faith and deal fairly with employees in the labor context. Occasionally there'll be an unfair labor practice filed, and we have to go to the state. You know, an example might be, let's say you decided to subcontract out, I'm just making this up because it wouldn't be practical, but all of your special education teachers, that would be a violation of the act and something that would be addressed through that channel. And there's something similar to your non-certified employees. That's typically dealt with by the Office of Labor Relations for the city. So you don't get involved, but the same rules apply. For example, if the administration, you know, took action against a union official because of, you know, in retaliation or something of that nature, it could trigger something like that, and there would be rights and a process that we'd have to go through. I mentioned the terminations and non-renewals, so I'm going to move on, but before I do that, I just wanted to note one thing, because this kind of relates to the Freedom of Information Act. In Connecticut, there is a statute that makes teacher evaluations and actually certified staff evaluations are confidential, and they're not subject to the Freedom of Information Act. The only exception to that is the superintendent of schools. Her evaluation is FOIable in a public document, but be aware of that in case there's some reason anybody wanted to see, whether yourselves or a member of the community wanted to see an evaluation of a teacher, that is prohibited. Now, I touched a little bit upon the Freedom of Information Act. And again, I'm not going to do a deep dive on this because it's a whole subject unto itself. And either if you want to do a deeper dive on that, either myself can do it or the state would send down someone like Tom Hennick from the Freedom of Information Commission, who free of charge would do a training on that. But, you know, basically when we talk about the Freedom of Information Act, there's two things. The first is records. And the general rule of thumb is every piece of paper, every piece of digital information that is in the possession of the Bridgeport Public Schools is a public record and is subject to disclosure. There are, however, exceptions. Those exceptions are narrowly construed, but there's a lot of them. So it would include things like student records. Those are not public records, they're protected. Things like security plans are specifically protected. Things like strategy for collective bargaining are protected, and the list goes on. But just understand the general rule is public records. If somebody wants a public record, they may make a request and within reason would be entitled to it. The other side of the Freedom of Information Act deals with meetings. Again, a lot of this is, you know, pretty fundamental. You guys deal with it all the time, but there are three types of meetings. There are regular meetings, there are special meetings, and there are emergency meetings. A regular meeting is one that's posted at the beginning of the year. Importantly, you may add something to the agenda of a regular meeting, but only a regular meeting, and you have to have a 2/3 vote to do that. A special meeting, you can only discuss what has been raised or identified in the notice, and you have to give at least 24 hours prior to those meetings. Now, an emergency meeting is one where you don't have to comply with the 24-hour notice. You can give less notice, say 12 hours, but the Freedom of Information Commission narrowly construes an executive session, an emergency. And emergency isn't, well, we want to address this right away. It really has to be literally a true emergency of some kind. So that should only be used in where it's a true emergency. Executive session, again, your meetings are supposed to be in public, like this one. And again, there are certain things that the Act says we understand are important that you be allowed to talk about that in private. And it would include things like litigation. It would include things like personnel matters. And there's a list of other things. The important thing is when you're in executive session, you only talk about the item that you go in for. And also that whatever is discussed in executive session should not be communicated to anybody else. If you do, you've basically turned it into an illegal meeting and are subject to penalties should somebody file a complaint over that. And on a more practical level, what it does is it violates the trust between members of the board. So I strongly encourage you to adhere to that. You may sometimes hear the term non-meeting when you meet. I know that sounds ridiculous. You know, it's what we sometimes call an oxymoron. But like jumbo shrimp or Army intelligence, but what that means is that there are certain things that the Freedom of Information Act says you don't have to follow the rules for. You don't have to post it. You don't have to keep minutes of votes. You can just meet. And one of those is strategy for collective bargaining. So let's say that Ms. Baptiste Perez wanted to update you on negotiations. You could do that before a meeting, after a meeting, take a recess and talk about it. Or if you wanted me to come in at the end, I will come and hopefully we get an agreement with the teachers and we bring it back and I explain to you what it is. You have to vote on that in public, but we could go into a non-meeting to discuss the pros and cons of that. Another reason for a non-meeting would be when you appoint yourself as the hiring committee, which you've done in the past. And a third, which I don't have here, but I know has been utilized in the past, is a meeting of one political party of the board. So if all the Democrats wanted to meet and talk, you could do that without having to post notice and so forth. What you can't do is bring anybody in who's not a member of the Board of Ed and of that same political party. And then just a couple last items here about Freedom of Information Act. One of which is it's an illegal meeting if you communicate about board business through, for example, email. So if one board member sends out an email to all the board members about a topic, so far we're okay. The problem is when somebody hits reply to all or replies to a quorum of the board. Now we've had an illegal meeting because you're discussing board business and you're not doing it in an open public meeting like this. So you should avoid, I would say avoid even that initial blast to the other board members because there's just too much of a tendency to respond to that and create an illegal meeting. By the way, it's okay if it's just a scheduling, kind of thing, who's around for a meeting of the finance committee, that's perfectly fine. But if you're discussing a topic, if you do it, it's an illegal meeting and there could be consequences for that. The other thing I would just like to say here is I mentioned how any written correspondence or digital information is subject to the Freedom of Information Commission. I'm sorry, a Freedom of Information request. That includes emails, but it also includes texting. And so, for example, if somebody caught wind that two of you were texting about, if a quorum of you were texting, well, even if it's just two of you were texting about a board matter, they could request to see your text messages. So it's best to communicate only via board email because then you don't have to worry about people trying to go through your cell phone. And it's easier for the district to be able to pull that information if there is a request, if it's through district email. Okay, just a few words about Robert's Rules of Order. Of course, Robert's Rules of Order, again, is something that could be a whole topic in and of itself. But it is something that goes back, hundreds of years. It's a process that was designed and tweaked over the years to allow entities such as yourself to operate as smoothly as possible. So there's rules about how it gets done. Importantly, there is no statute governing Robert's Rules of Order. The only reason that you folks have to be concerned with it is because you've adopted it in your bylaws, as frankly does virtually every school district I'm aware of, and it's a good practice because, again, it allows you to have rules to follow to get things done in an orderly fashion. It doesn't have the force of law, so if somebody violates it, you can't exactly go to court to enforce it. Although there is one approach or one theory, but it's not like the violation of the Freedom of Information Act, where you could go to the Freedom of Information Act Commission and file a complaint. But having said that, because it is your sort of internal law, because you've adopted it in your bylaws, it is something you should follow and take seriously. So I've been going on for an hour now. So at this point, I'll just wrap up by saying a couple of do's and some don'ts. Exercise your right to raise questions, propose actions as a board member in meetings. Exercise your right to dissent. That's your privilege and right to do that. However, maintain decorum, show the children in the community how we expect the leaders of the community to act. Things that you should not do is to freelance without authorization. You know, as I alluded to before, don't enter a classroom to observe a teacher who you've heard some things about. Don't engage in backdoor bargaining, whether it's about a roof replacement project or a collective bargaining agreement or anything of that nature, because again, you don't have the authority to do that except when sitting as a board or unless delegated, as in the case of the teacher contract, to negotiate on your behalf. Don't disclose confidential information, whether it's from the executive session or other information you may come in contact with. By disclosing confidential information, you open yourself and the board to potential liability, and again, it leads to distrust. Don't attempt to handle parent or citizen complaints. Refer to the administration and follow the chain of command. It can create a whole slew of problems, including, potential liability for the district, turning yourself into a witness and making you have to recuse yourself if that topic comes before the board. You should not be doing that. These last documents I'm not going to go over, but it explains, I've attached this because it explains your role in the process if a grievance comes before you. There's basically two types. One is discipline, in which case the question you're going to be asked to address is whether there was just cause for the discipline that was issued by the administration. As a personnel matter, typically that would be done in executive session. And then the other is, a language grievance about the interpretation of a contract. Somebody may grieve that they're not getting the sufficient number of prep periods or something of that nature. If that comes before you, then the question is usually the question would be whether the administration has violated the collective bargaining agreement. If and when it comes time for one of those grievances, I will walk you through that process and what your duties and responsibilities are. We've been pretty lucky the past couple of years. We haven't had very many of those, which means not only are we following the rules, but we've got a good relationship going on with the primary union. So, Ms. Brown, my voice is running out, so I'm going to stop at that point.
Thank you, Mr. Dugas, for sharing your presentation, and board members, be mindful that this information is in your packets. What I'll do is I'll take an opportunity to go across and ask board members, do you have any questions to Mr. Dugas this evening? Anything that needs to be clarified? If you don't understand something, this is the opportunity to do it. So definitely, you can raise your hand or I can call on you, but I was going to go down the list. So the first person I see is Mr. Benningham. You have the floor.
Thank you, Madam Chair. Thank you, Mr. Foy, so much for the information. You clarified a lot of things that I like to know. The first is not a question, but it's a comment in the way I feel like why we are board members. we represent the district Bristol School very well. That's the community, and everyone votes for us to represent parents, staff, students, and everyone whoever is around. And Bristol is one of the big cities we have in Connecticut. We have a large, and with the large of students, schools, and we have. It's not easy, but I know we're trying to do the best we can. My first question is, I know, Madam Chair, you just said Mr. Floyd will send us everything he was saying, and is part of the package. My question is, because I'm going straight, what happened if Dr. Carmela Levy-Davis not make action, not make the action or not report, or something happened with one of the situation happened with the staff, it is not done, it's not fit. We trying to speak to her, we report her, and nothing is done. And she got fat, she got everything. What's going on if us as the board member or the Madam Chair, Ms. Brown or whoever is gonna come be the chair the next time after November? What's gonna happen if the superintendent does not follow the protocol, the rules? That's my first question for you. I have another one.
Sure. So, as I alluded to before, the superintendent is the one who's supposed to be running the school district and dealing with those issues. So, for your unionized staff, which is most of your staff, teachers and administrators, if they think something has been done incorrectly, they have a right to grieve it. They've got a right to file an unfair labor practice, and it can be addressed in that fashion. As I noted, your responsibility is not to supervise and deal with the staff. That's the superintendent's role. You're really not supposed to be getting involved. Now, let's say hypothetically, you're hearing all kinds of problems with how the superintendent is dealing with staff. I would say you address that in your evaluation process with her. And so that would be, you could also go into executive session with her to discuss her performance. And that would be another way to address that. But it would not be appropriate for you to, sort of take over for her and deal with the situation. Hope that answers your question, Mr. Bennett.
No, you answered correctly. Of course, I would not take over. I know it's a protocol. That's why we have a chairperson, and after that, the chairperson will make the process like you said. I know in the beginning you said something about PTO, and just let me inform you, it's not, you're talking about PTO, you're talking about the school things, right?
Yeah, that the parent.
Yeah, but it's not, we don't have, Bridgeport School, we don't have no PTO, it's called PAC or PTSO. So I want to correct that situation.
All right, thank you.
And everybody know I'm part of that. And just want to inform you, and I just want to ask you, when we got leaders, they're very lost. They don't know what to do. They don't know what to go. Or they don't help them, or they don't give them the correct information. Sometimes leaders from other schools, they talk each other. They say, oh, I didn't know that. Oh, why you have this? Oh, this information is not right. That's why sometimes all these PAC leaders and PTS or leaders from Bridgeport School come to me or come one of the board members to ask questions. I'm a kind of person, I don't like to ignore nobody because I don't like to be ignored. I also would listen to them, be almost 20 years in the district, have the experience as a PAC in PTA. So about the bylaws and everything. Of course, I'm going to be there to help them. Of course, I'm going to try the best they go the way it's supposed to be in the bylaws and everything. So I just want to be sure, because sometimes when they say a board member come to the school, help or support one of the PAC and PTA. So they think they're going to come to run the school or tell the principal or tell the staff what to do. That's not my role when I go to the schools. I help the PAC and PTA. So I want to clarify that, and I hope, people understand what is my concern about the PAC and, PTA. So.
Got it.
Also, my other question is FredPAC. I really have a very bad experience with FredPAC. My question for you is, what's going on when the board member break the policy of FredPAC? What's going to be the consequence, and what's going to happen?
What theoretically could happen is that, so if somebody were to file a complaint with the Office of Civil Rights of the U.S. Department of Education, if they file a complaint, the first thing that happens is the OCR, the Office of Civil Rights, will come down and do an investigation. And by the way, when they come down, they usually just don't limit it to that specific complaint. They really poke their nose around to find out if there's much larger problems. Are you complying with, other things you're supposed to be complying with? And then again, in theory, if they find a violation, they can penalize you by denying you federal funds that are happen. I'll be honest with you, that's a pretty rare occurrence. Usually they just want people to comply with the law. So let's give you an example. Let's say that there was a data breach involving student data. Pretty serious, and maybe it's a list of special education students, or it's just, a list of students' names. They would consider that very serious, and they would come down on you pretty hard and make you do a lot of training and compliance. And, that's the sort of thing that can happen.
Because I'm asking this, is that policy can be open, let's say for parents, let's say, like give example 2 or 3 years back, but the FERPA never did nothing, for the parents feel that, feel bad because they never did nothing, and they break one of the board members break the policy. But so they have a proof, they show him, everything, and it's witness, it's fact, it's documents, but FERPA never did nothing, never support that parent to cover the privacy of that students. That document still open, or after how long they will be closed?
It's a good question, and the best answer I can give you is like any big bureaucracy. Sometimes it takes them a long time to get to something, but especially during the COVID period, as you can imagine, it was really hard to get things resolved. So I'm not familiar with the specific situation you're talking about, but usually things don't generally fall through the crack there. It may take a long time to get to, but things don't fall through the crack if a complaint's filed.
Okay. And my last thing is, maybe you can send me a question or comment, but we have to understand, us as a board member, we got parents, we got students, we got staff, we got community people working in the Bridgeport school. They always come to us to talk to us. Let's put it this way, staff. Sometimes they feel they don't listen to them. They're not listening to concerns. They're not fix the situation. They feel alone. They feel lost. They feel what I can do. If I say something, Mr. Benehan, I know they're going to put something in my record. They're going to go after me, and then I'm going to have this and that. And I hate when the staff feel that way. So as a board member, I have a lot of things. I got a lot of stuff that comes to me, and I know how part is my role. Let's see, I can tell you when it's about DCF, law, policy. I always tell them, listen, that's what you have a supervisor. That's what you have in the union. But is this something simple that I would like to listen to them? Because like I said, I don't like to ignore nobody. They have to understand, I know we got policy, we got union and stuff like that, but I want to be for sure for the record that me as a board member, and I know another board member that will do the same, they would like to listen to our staff because they work very hard. They're not easy what they're going through, and I respect them so much. I wish I can give it to them what they need, but we got a protocol and policy, we have to follow the process. But I want to be sure that as a board member, I don't like to ignore my staff. I know how far I can get, so I want to be sure, to that, and I hope it's not bad when the staff come to us and talk to us, just to listen to them. And sometimes we can help them, or of course, with the Madam Chair, we let them know the situation, or with Dr. Love David, and we guide them the way it's supposed to be. Are you okay with that? That's my question for you.
The official party line answer out of CABE, National School Board Association, is you should simply refer them to the superintendent, the chain of command. Listen, I'm practical. I recognize, aside from your role as a board member, you're a leader in the community, and that's an important part. But what I would say to folks is, it never hurts to listen, right? Sometimes people just want to be heard. So you listen to them, and then, the easiest thing to say is, have you talked to the principal? Have you talked to the superintendent? I'll mention it to the superintendent. That's the easiest way. And not only, in most cases, hopefully the administration is sort of better equipped to address the situation and deal with it. And again, I mentioned the thing about authority. You really have no authority outside of a meeting like this. And maybe you don't mind, but the more you do that, the more people come to you because they think you're gonna do things. And it not only does it create more take more of your time away from your family and your personal life and all of that. But frankly, it undermines the administration.
Yeah.
So listen, be empathetic, but, then say, well, I'll pass it on, or did you talk to?
No, I just want to be sure because I don't want to feel that, oh, Mr. Bennett talking about this person, whatever, blah, blah. No, I would like to listen. And like you say, I will guide them the way it's supposed to be because I care about them. It is very important, in Bristol School. Thank you, Mr. Floyd, for now. Thank you, Madam Chair. I appreciate it. No comment, no questions for now. Thank you.
Okay, thank you. Mr. Traber, your hand is up.
Thank you, Madam Chair. A couple of quick questions, Mr. Dugas. With regard to, sharing info, is there a limit on the number of people? I mean, if I'm having a conversation with one person or texting with one person, is that with regard to FOI?
Quorum.
So what's the
answer is a quorum of the board. So you guys have, yes, sir.
Okay. With regard to changing agendas, you mentioned regular board meetings versus special board meetings. What about committee meetings?
Committee meetings should follow the same rules as any other meeting. Committee meetings are considered a meeting under the Freedom of Information Act. So whatever the rules are, there, you need to follow the same rules.
I'm talking about the committee meeting with regard to changing of agenda items. You said there was a difference between changing the agenda for a regular Board of Ed meeting versus the changing of agenda for a committee meeting. I mean, for a special meeting. So I'm asking you, what is the rule regarding changing an agenda for a committee meeting?
So a committee meeting is in effect a special meeting.
Okay.
And therefore the same rules would apply.
It can't be changed.
Yes, sir.
Okay. And last, with regard to the potential grievance duties of the board, acting as adjudicators, the rule then should be for us to avoid engaging in detailed discussion with administrators up to and including the superintendent about cases that may come before us later.
Absolutely.
Thank you. That's it. Thank you, Madam Chair.
I don't see any other hands up, but I will acknowledge everyone.
I got it.
Up. I don't see Mr. Sokolovic. You have a question? Yes. Okay. Go ahead.
I was trying to read. I couldn't find it. I'm sorry. Thank you. Just a quick question. We mentioned documents and providing them to the public and if them. Could you go over a little bit about the new state law about putting the documents in the portal? Because that's on our next agenda. It might save us a few minutes.
Yeah. What it basically says is that your agenda, it says agenda or materials. I sort of take that as both. Whatever is going to be shared with the board is supposed to be available to the public and posted on your portal. That's the essence of the new law.
Thank you. That's all I got.
All right. Ms. Perez, do you have any questions?
Pass for now.
Ms. Casimir, do you have any questions?
Yeah, just two quick ones. Can you hear me?
Yes, ma'am.
You're good.
Okay. I want to talk just a minute about the lawsuits when you talked about, or potential lawsuits, when you talked about governmental immunity and indemnification.
Yes, ma'am.
So with a combination of those two right there, would that be equivalent to individual directors and officers insurance that insurance companies offer?
Sort of. The school district maintains a bunch of, through the city, a bunch of insurance policies, including, I forget what it's called, but it's the equivalent of officers and directors liability. And so in general liability and umbrellas and everything else. So there's, for most situations that I see come up, certainly the slip and fall or, any kind of, trad, that sort of stuff it's almost always covered by one policy. It's just a question of figuring out which one. But there's something, they always have exclusions, right? Might be for asbestos or something, so anyway, there are exclusions, but generally speaking, yeah, there would be the equivalent coverage for something like that.
Okay, great. So then it wouldn't be necessary to purchase directors and officers insurance if you have, the governmental immunity and the indemnification. And
city insurance on top of that. Yeah.
And city insurance. Okay, great. That's perfect. Thank you.
You can sleep tonight,
And my last question is meetings, under the meetings section. So Mr. Benahan is definitely out there in the community, and he attends as much, as many like school events and community events as he can, and that's great. But I have a business question about that. If Mr. Benahan tags all of the board members, let's say that he's on the friends list in Facebook of more than a quorum or a quorum, is that considered a meeting when he tags us in a picture or a video saying, oh, look what we did at Columbus School today, look at the students, look what we did, like real, good stuff that he always does? I want to know, is that technically a meeting when he tags at least a quorum of the board?
Yeah, that is a great question. And the general rule of thumb is, social media is no different than a text or an email. So the same rules apply. So if that were to happen, as long as a quorum of you don't respond, and as assuming, and if it doesn't relate to board business, let's say that there's some community event, nothing to do with the schools directly, but a community event, totally fine. You can respond to that. But let's say, here's something going on at the school, and you know what, we need to fix that basketball court. It's got a crack in it outside.
Okay.
And you guys respond. Now it's board business. And just because it's through social media, it's the exact same rules.
Thank you so much. It was a burning question of mine. That's all I have. Thank you.
You're welcome.
Ms. Baptiste Perez, do you have any comments or questions?
I'll follow up with Ms. Casimir's last question. Mr. Dugas, when it comes to parents or members of the community, so let's say a parent tags more than a quorum of the Board of Ed on a basketball court needs to be fixed. As long as we don't respond, then that's going to protect us from quote unquote conducting business, correct?
Correct.
Okay. On a similar note, if a parent reaches out to the Board of Ed via email, and it's to the entire board and superintendent, and discloses information regarding her child, the student, or his child, the student, including name, school, address, contact information, it's probably with the utmost caution as a board member not to respond and probably not to reply all, depending on the context of it because of FERPA, correct?
You are absolutely right. Parents do that, unfortunately. And, the fact that the parents sent it out, that's, to you, that's not a violation on your part. It's essentially a waiver or an authorization on their part. But it can get really dicey if you respond back. And now you're talking back and forth about, the child. That's where the problem comes in. So you're 100% on point.
Okay. And then if it does, I'm just going to continue down as everything connects. And if it does seem that a board member does it can be somewhat of a trap to a certain extent, or a waiver, as you explained. Is there particular actions or conduct that the board executive committee, whether it's the chair, can take or speak to certain board members to prevent issues like that from arising?
Sure, of course, a reminder is always a great place to start, please don't hit reply all again, if it becomes, an ongoing problem, of course, again, you can always discuss a board member's performance in executive session. What you can do about that is fairly limited, but you can certainly talk to them in executive session as well.
I'm glad you brought that up. So in situations where board members may act out of conduct, it can vary from that to maybe not acknowledging items that should have been on the regular board meeting. What are the kind of actions a chairperson can take for board members that may violate? So you mentioned one is probably meeting with the board in executive session. But in my experience on this board, I've seen members being stripped of their committee responsibilities. But what else can a chair potentially do to reprimand a board member for violating our bylaws or potentially exposing the board to liabilities?
Yeah, that's about it. I mean, there's something called a censure. I don't want to say it's a slap on the wrist. It can have more meaning than that, but it's an indication to the community that somebody's not behaving and doing what they should, and maybe that comes into play the next election, or so forth. But those are really, off the top of my head, really the only tools in the toolbox.
Okay. Then I want to pivot back to social media. In terms of personal posts that may be shared, because we do hold hats and you explained this in the beginning of your presentation, we have our role with the state, we have our role with the city, the district itself. When it comes to exercising our First Amendment via Facebook posts, I started to look at some articles from like from different law review articles and regarding posting online and whether our speech is considered speech of the board. Do you suggest board members create political pages to kind of bifurcate, this is my personal Facebook page and this is my political Facebook page? Should we have, like, if there's a highly contested election going on right now in Bridgeport with a lot of additional stuff going on?
I hadn't heard.
Yeah, it's not on the front page of any paper. Should we put, this is my personal opinion, like, I guess a little kind of warning or asterisk saying this is my opinion as an individual, not a opinion of the Board of Education?
Yeah.
There's a lot, there is a fine line that goes to it with free speech, but I just wanted some kind of clarification or understanding, like, is there some kind of best practice to avoid any kind of pitfalls, or what can be considered hostilities amongst whoever the leadership is in the city and state?
Yeah, I mean, first of all, I can't even begin to tell you how many student matters, teacher discipline matters, police officer discipline with social media. I'm going to sound like a dinosaur, but I wish it wasn't invented, but by Al Gore, I think it was. But anyway, I think you're right. If and when possible, if you can identify that it's your own personal opinion, clearly you don't want to have a Bridgeport Board of Education logo, but under your name as you say it, because now it sounds like you're speaking for the board. So just avoid anything that suggests that you're speaking for the board. And yeah, you're again right on, to the extent you can say, this is my personal opinion, especially if the context in which it comes up, somebody's tagged you or identified you as a board member, or they raise it, best to say, yeah, my own, this is my own personal opinion and not necessarily the opinion of the board.
Okay. And then I'll hold the rest of my questions, so in case any other member has additional questions, because I could probably go on for a while, but be interested in what else everyone else has to say.
Mr. Gellan? Comments or questions?
No comments or questions from me. Thank you.
Okay, and now come back to Ms. Perez.
I'm all set now. Thank you.
All right, so everyone has had an opportunity to speak. If there are no further comments or questions, unless that's it, Mr. Dugas, do you have anything else to share? Okay, Dr. Levy-David, I see your hand.
Good evening. Yes, I have a couple of questions actually. Because it has come up quite a bit in board meetings, and I really want to be clear about what exactly the regulations say about the superintendent's obligation to invite board members to public events that the superintendent receives an invitation to.
I'm not aware of anything in statute regulations. I don't think there's anything in your bylaws on that, so I'm not aware of any obligation to do that.
Okay.
Now, obviously there are social norms and expectations, and it has nothing to do with legal requirements, so I'll just leave it at that.
Okay. What about when the superintendent receives requests from board members to donate to political campaigns?
Well,
What am I supposed to do about that?
You obviously have no obligation. I'm not sure I've ever heard of a superintendent donating to a political campaign in their town. I think that could create some trouble, some backlash for you.
Okay. So I'm not obligated to do that.
Oh, you're certainly not obligated, no.
Okay. Should board members be asking me to donate to their political campaigns?
Again, I think that would be, I would say, you certainly have no legal obligation to do that. And again, I think most superintendents would find that would be problematic potentially problematic if they did that. Not legally, but just in terms of their relationship with the board.
Okay. What about when I receive complaints about principals and events they're hosting at their buildings or have decided not to host at their buildings from board members? What is my obligation there?
What sort of events are we talking about? Parent, learn to read night or political?
I'm talking about events, a particular event that maybe was going to take place and for whatever reason, the principal decided to cancel it, or a local minister asking to use and renting the space legitimately and receiving complaints from board members regarding whether the rental was legitimate or not. I have a long list.
Yeah, I mean, well, it's your role as superintendent to address it if you think it's inappropriate or wrong or violates district policy. I mean, that's your call to make. Without knowing the particulars, I can't really comment any more than that.
My concern is for building leaders and their ability to lead their campuses without undue intervention from the superintendent unless it's absolutely necessary, and not creating a chilling effect for building administrators in the autonomy they have and the rights that they have to make decisions for their campuses, and my limiting my intervention in order to allow them not only to grow, but to prosper as leaders by practicing those very, I would say, necessary decision-making practices for their campuses and for their staffs. So I wanted to make sure. Also, what about when I receive complaints from board members about expulsions and how I should or should not handle a student expulsion?
That again, that is a very legalistic process. And board members should not be, except for when a recommendation comes to them for approval at a board meeting, they should not otherwise be involved in that process.
Okay. What about board member messages via email to members of staff that are abusive or hostile in nature and border on unprofessional? Would a conversation suffice? How do we set boundaries around that so that employees don't feel harassed?
Again, the chain of command is that board members should not be, communicating directly. I mean, they certainly can communicate a parent concern with the chain of command. Other than that, again, it's the role of the superintendent to deal with those issues.
Okay, I'm sorry to belabor, but I do have a lot of questions. What about when a board member says to a district employee, "You are my employee," not the superintendent's, but my employee, specifically in a public place, says that to a member of personnel or staff from the district? How should I handle that particular incident?
I'd remind the employee and perhaps the board member that in fact, they don't work for the board. They certainly don't work for the board member. And they don't even work for the board. So that's, legally not accurate.
I've received multiple complaints about the things that I'm mentioning, which is why I'm bringing them to this special meeting to get clarity so that I can also respond to the employees that are lodging these complaints before this gets out of control and we have a larger issue at hand. So I'm grateful for this. What about purchases for board members? What are we as the district obligated to make as far as purchases beyond paying for conferences and things of that nature?
That would be subject to whatever your board policy is. I think you have a policy on that issue, and I would defer you to the policy. I mean, it's not illegal or improper to reimburse board members for out-of-pocket expenses, but again, usually there's a board policy on that issue. If for some reason there's not, I would encourage you to have one.
What if they're asking for purchases to be made, not for reimbursement, and they're doing so in writing?
It would depend on the circumstances, but some districts have bought computers for board members to be able to utilize, and that's certainly appropriate and reasonable. So, I don't know what more to say other than that.
Okay. What about when the superintendent receives photographs of students asleep from board members?
Obviously, the superintendent should refer it to the principal so that the principal can address it with the teacher.
No. I'm receiving photos of students who are asleep from a board member, but they're not in a classroom.
Is a student asleep in the classroom?
The student is asleep
in the classroom.
In the lobby, in the superintendent's lobby.
I'm not sure how to respond to that, to be quite frankly.
I don't either. I was hoping you could guide me on that. I think I'll withhold some of my questions for later. Thank you. Appreciate it.
You're welcome.
Ms. Baptiste Perez.
I know the answer to this question, but I forgot the legal answer as to why. Mr. Dugas, board members cannot be removed from the Board of Education. And could you just tell me the legal purpose again for that?
Sure. The concept, and this has been litigated, and I know our office has written opinions on this in different, not for you guys, but for other districts, but it's basically the reason a board cannot remove a board member is because you would be taking away the voters' rights. That's basically, you'd be it's disenfranchising the voters if you were to do that. So it's basically prohibited. Now, you can remove somebody from an office on the board, subject to your bylaws, whatever they say, but you cannot remove a board member from the board because that's disenfranchising the voters.
Okay, thank you.
You're welcome.
Mr. Sokolovic, your hand is up.
Yes, I heard a lot of assertions, about emails, pictures, and stuff like that. Is it possible to have all those assertions forwarded to Mr. Dugas and have the names and everything highlighted out just so we could all be on the same page as to what she's talking about?
That's not a question of mine, answer, so I'm assuming, Dr. Levy David.
I think, I guess that for if, these things could lead to possible litigation, I don't think I should forward them. That would be, I would have to receive legal advice to whether I should forward these items.
Wait, hold on, go ahead. Are you finished, Dr. Levy David?
I am.
I apologize for overspeaking, but if it goes to our lawyer, that's lawyer-client confidentiality, so it doesn't expose us anymore. And then we can discuss it in an executive session if there's a possible legal ramification and get legal advice on how to proceed on these issues you've raised that seem to be very important that needs to be addressed.
Well, if you ask me for advice and I respond to that advice, that's covered by the attorney-client privilege. I'm not sure sending me a photograph or an email or something else would be, but I'd have to take a look at specifically what it was.
All I'm saying is these concerns are rising to this level where they need to be addressed at this meeting as potential liabilities. I think we should get on top of this and really be proactive before we get sued on one of these items Dr. Levy David has brought up.
Well, I took all of these as hypothetical questions to the extent they were real situations. I wasn't necessarily weighing in on them, and I'm not, with all due respect to you and Dr. Levy David, I'm not sure it would be constructive to hash these things out, but I'm your counsel. If you want me to look at something, I'll certainly do that.
Yeah, I think that there's no action to be taken at this meeting, but it could be an interesting agenda item on a committee or the regular board.
Ms. Baptiste Perez.
I have a very simple question, just with regards to my duty as a board member. As an elected official on the Board of Education, am I a parent advocate?
I would say no. You are an advocate for all the children of the city of Bridgeport and the Bridgeport Public Schools.
Gotcha. And am I an advocate for staff?
You are not. That would be called a union delegate.
Nope, I completely agree. I just wanted to make sure I understood. I'm not an advocate for parents. I'm not an advocate for staff. And then to a similar extent to the hypothetical I gave you, if a parent reaching out potentially the waiver situation, if a employee of the district or a contracted employee of the district reaches out to the full board complaining of a circumstance, is that another situation where we just forward it to the chain of command depending on the type of situation?
Absolutely, and depending on what information, it could be a FERPA violation.
Okay. I don't have any other questions right now, but thank you.
You're welcome.
Mr. Benningham, your hand is raised.
Yes, thank you, Madam Chair. Mr. Floyd, I have a question for you. If as a board member, and I feel discriminate because my language, because where I come from, because my speech, because my email, the way I am, because I'm 100% Puerto Rican. I don't born in the United States, and I'm a Spanglish, like people say, is very different. If I feel like that as a other board member, discriminate the way I am, What is the process, or what I can do, or where I can go?
I'm sorry, if you feel you'll be discriminated against?
I feel as a board member, I'd like to know what I can do. What is the process? Because if board members are say words or say things that because the way I speak, the way I send an email, the way it's my language, as I say, I'm 100% Puerto Rican. I was born in the United States. In my English is, is not perfect as you, a citizen of the United States, or born here. But I know I defend myself and I open my mouth the way it's supposed to be to defend my people. So if I feel like that, what is the process of what I can do?
I honestly, I'm not, I don't know that I can give you legal advice. I would just generally say, I was going to say that the discrimination laws generally protect students and they generally protect employees. Honestly, I've never had anybody ask me if they cover board members. That's something I'd have to research.
Okay, if there are no.
Hold on, Madam Chair, sorry. And my last one is, just to clarify, so I put it in my notes, because I'm going back what Ms. Akisha said. If we don't talk about the situation, if I attack about social media, let's put it Facebook, we don't talk about the situation that happened in the building, it's not like a meeting, cannot be a meeting. It's just something, an event, they have a party, they have a picnic, they have something. Look, guys, because I'm the one attack my board members. Look at this amazing picnic. Look at this amazing perform. Look at what beautiful the student did. Because I know parents and teachers love when board members say something nice, something positive. Trust me, they love it. They enjoy it. They say, thank you, Mr. Bennett, to let them know the board members. So we okay with that. But if we don't talk about any issues or situation in the school, everything after that, everything's fine, right?
Yeah, I mean, more broadly, I'd say matters over which the board has jurisdiction. It could include things other than what's going on in the schools, but yeah.
Okay. I just want to clarify that. All right, thank you. Thank you, Mr. Floyd. No more questions, Madam Chair.
You're welcome.
All right, if there are no further questions, I don't see any hands raised. Thank you, Mr. Duke. Okay, Dr. Levy-Davis, I see your hand is raised.
Thank you, Ms. Brown. Mr. Dugas, what is the recourse? What do you advise a superintendent to do if a board member writes an email that they don't care about FERPA, records it in email? How do I support that board member in understanding just how critical FERPA law is to our students and to funding for the district?
You might want to refer them to the Office of Civil Rights website on FERPA. Personally, I might be inclined to ignore it, but maybe the more responsible thing is to refer them to the U.S. Department of Ed. And I forget the name of the specific department that oversees FERPA, but refer them to that.
Okay, and this one is a bit more sensitive, but I'm going to bring it up. If after receiving an invitation to donate to a campaign and not responding, a board member's tone and treatment of me completely changes to one of hostility, do I have legal recourse?
Well, again, I can't give you legal advice, and with all due respect, I think I'm being dragged into the middle of a fight on something, and I think it's probably best I not get tied up in that.
Okay. I'm just curious because I think that if superintendents should not get involved in politics, which has been made very clear to me my entire career, and I think that I've done an excellent job of not getting involved in politics in Bridgeport, because politics is very controversial, and politics definitely, it's something that raises and destroys whole countries. And I feel like there's undue pressure to support someone's campaign. And the once cordial, daily friendly emails are suddenly translating into something else, morphing into something a little darker. That concerns me. I want to address that because it does concern me.
You know, they say that the boards that work best are apolitical. I realize I'm dealing with Bridgeport, and it's a, you know, I mean, it's a reality, but you know, I've been doing this for 37 years, and I can say wholeheartedly the boards that are most effective in advocating for kids and do things, leave the politics at the door.
Okay. Well, I really appreciate your guidance and your advice. I think it's been very illuminating, especially for me. I can't speak for anyone else, but it's definitely been illuminating for me because I have been very observant and definitely counseling employees regarding some of their experiences with members of our board. And I want to make sure that I can protect our personnel, our staff, and ensure them that they're not in a hostile work environment, that their jobs are not in danger, that they're not going to get fired or penalized or harassed or in any way ridiculed if they are not basically doing what a board member wants them to do, whatever that may be, whether it's part of their job, their duties, or whether it's reasonable or unreasonable. And I want to make sure that that's clear. Everyone deserves to come to work and be treated with respect. Every single person, including myself. Everyone deserves to feel like they're in a safe and hospitable work environment. And of late, I've had a lot of difficulty in protecting my employees and in feeling that way myself. So I'm glad that we had this meeting and that we were able to clarify some of these pieces, because I want to ensure, because I can actually, I mean, I know how to advocate for myself, but I want to make sure that those employees also know how to advocate for themselves and they feel empowered to do so and not afraid of retaliation because they live in the small town of Bridgeport and their whole family lives here as well. So I really thank you for that. Appreciate it.
Thank you. If there are no further questions, Mr. Dugas, thank you so much for joining us this evening, spending the time that you have. We appreciate you and we thank you for the opportunity that you provide for the board and the information. At this moment, I will entertain a motion to adjourn.
Motion to adjourn.
Moved by Ms. Jennifer.
Second.
Second by Ms. Casimir. Any further questions or comments? Hearing none, all in favor?
Aye.
Aye.
Aye. Any opposed? Any abstentions? Hearing none, the ayes have it. Thank you, Mr. Dugas, and board members, we'll see you on Saturday for your CAPE training. Thank you and have a good night, everyone.
Thank you. Good night, everyone.
Have a good night, everyone. God bless you all.